On August 20th, 2013, the amicus team filed 2 preliminary objections to these proceedings. The first, contending that there are defects in the charges preferred against the accused, and the second, contending that the State of Israel cannot be impeded in these proceedings on the grounds of state immunity. The main thrust of the amicus team's arguments in its first preliminary objection is that the trend in modern international criminal tribunals is either to have jurisdiction for acts that have been committed after these tribunals have been constituted, such as the International Criminal Court, or alternatively, its jurisdiction is for a limited duration of time, such as the International Criminal Tribunal for Rwanda and the Extraordinary Chamber in the courts of Cambodia. The amicus team submits that the tribunal came into existence on June 6, 2008, while the various acts allegedly committed by the accused in charge number 3 occurred in the month of September 1982. While the acts allegedly committed by the accused in charge number 4 occurred since 1948 and continue up to the present day. The amicus team openly concedes that if the tribunal holds that its jurisdiction is open-ended, as in the military tribunals of Nuremberg, Tokyo, and Guantanamo, then its preliminary objection must fail. This morning, the tribunal allowed the amicus team to make its oral submission in respect of the same 2 preliminary objections. On behalf of the prosecution team, it was argued that the jurisdiction issue must be established by reference to the founding charter or statute that sets up the tribunal. The charter of the KL Foundation to Criminalize War states that the jurisdiction of the tribunal shall be governed by the provision of this charter, Part 1, Article 1. There is no temporal limit. In particular, Article 7 sets no time limit. In this sense, the charter is identical to the open-ended temporal jurisdiction of the tribunal at Nuremberg or the International Military Tribunal for the Far East. The prosecution team also submitted that the tribunal had convicted Bush and Blair of war crimes committed in 2003, which also predates its setting up. See the KL War Crimes Commission against George W. Bush and Anthony L. Blair, 2011. The verdict by the Kuala Lumpur War Crimes Tribunal against Bush, Cheney, and Rumsfeld et al. Went back to torture committed from 2001. The main thrust of the amicus team's argument in its second preliminary objection is that there is no authority conferred by the Charter on this tribunal to hear any action against the government of a country, for example, the government of Israel. The amicus team also argued that international law does not allow the State of Israel to be impleaded as an accused. The State of Israel is a nation-state recognized by the United Nations, and as a nation-state, it has rights under international law. The amicus team further submits that the State of Israel has not entered appearance in these proceedings and has therefore not submitted to the jurisdiction of this tribunal. The amicus team submits that the State of Israel enjoys immunity for the crimes of genocide and war crimes, and therefore charge 4 should be dismissed. With regard to the second preliminary objection, the prosecution team submits inter alia that these 2 charges are international criminal war crimes being adjudicated by an international tribunal. States have no immunity for such crimes before such tribunal. In support of the contention, the prosecution team cited the decision of the ICJ in the Bosnia case, which states in part as follows, and I quote, "Accordingly, having heard the various arguments, the court affirms that the contracting parties are bound by the obligation under the Convention not to commit through their organs or persons or groups whose conduct is attributable to them genocide and the other acts enumerated in Article 3. Thus, if an organ of the state or a person or group whose acts are legally attributable to the state commits any of the acts proscribed by Article 3 of the Convention, the international responsibility of that state is incurred." Unquote. On 15 October 2013, the amicus team submitted 2 applications to quash the charge against the 2 accused, Amos Yaron and the State of Israel. The grounds of the application as submitted by the amicus curiae are as follows. 1. The charge is defective for duplicity and or latent duplicity. 2. The charge is defective for uncertainty. And 3. The charge is an abuse of process and or oppressive. On behalf of the 2 accused, the amicus team sought for the tribunal to make the following orders. 1. The charge against the 2 accused be quashed. 2. That the prosecution against the 2 accused be permanently stayed. And 3. In the alternative, that the charges be redrafted according to the principles of criminal law. The amicus team contends that there were multiple offences within one charge and multiple forms of alleged instances of criminal conduct within one charge. The amicus team submits that the rules against duplicity must be strictly adhered to in a criminal proceeding. The rule prescribes that for every distinct offence of which any person is accused, there shall be a separate charge, and every such charge shall be tried separately. The amicus team submits that it is incorrect to say that the principles of duplicity do not apply in international criminal law, and submits further that the right to indict on cumulative charges under international law does not provide a complete freedom to avoid principles of duplicity or abuse of process. Such right to indict on cumulative charges must be subject to the overarching principles of clarity, precision, and fairness to the accused. The amicus team further submits that the charges against the first accused and the second accused ought to be amended at the very least, if not altogether quashed. The amicus team submits that the defects are so substantial as to warrant censure. They are prejudicial and fail to use impartial language as expected in the role or office of the prosecution. In rebuttal, the prosecution team submits that this tribunal is governed by its own rules, and these rules are silent on the application of the rule against duplicity in drafting charges. This rule against duplicity, as it exists in national legal systems, does not and cannot apply in the same way in proceedings before international criminal courts. More importantly, the tribunal should take into account the heinous nature of the crime and the scale they were alleged to be perpetrated. On the amicus team's submission that the charge is defective due to uncertainty, the prosecution team submits that it is premature for anyone to say so without appreciating the particulars contained in this charge. The particulars in the charge are facts that the prosecution seeks to prove in the course of the proceedings. The amicus team had also submitted that there has been lapse of time from the occurrence of the alleged crimes to the date of these proceedings. This gives rise to probabilities that critical evidence in support of defendant's case may not be available, hence significantly prejudicing the defendants. In response to this, the prosecution team refers to the setting up of the extraordinary chambers in the court of Cambodia in 2005 to hear cases of the Khmer Rouge atrocities from 1975 to 1979, and now the finding of the tribunal. Having considered the preliminary objections raised by the amicus team and the two applications filed by the amicus team and the submissions by both the amicus team and the prosecution team in the several documents already filed with this tribunal, and having considered further oral submissions by both parties, it is the unanimous finding of this tribunal that the preliminary objections and two applications have little merit and are accordingly dismissed. Before we terminate the preliminary proceedings and proceed to hear evidence in respect to the two charges, this tribunal wishes to state for the record the following. On the issue of its retrospective jurisdiction, 1. This trial is not criminalizing what was not criminal before. There is no issue of autrefois acquit or autrefois convict. The Charter of the Kuala Lumpur Foundation to Criminalize War empowers the Kuala Lumpur War Crimes Tribunal to take cognizance of and to adjudicate on heinous crimes under a plethora of pre-existing international statutes and norms. 2. Many other international tribunals have similar retrospective jurisdiction, although within specified time periods that commenced before the tribunal were established. The Kuala Lumpur War Crimes Tribunal has no such time limits. It is empowered to take cognizance of international crimes committed in unlimited time periods prior to its establishment. 3. It is also noteworthy that many of the international crimes mentioned in the charge sheet are continuing. And 4. We were invited by the Learned Counsel for the prosecution to follow the model of the Nuremberg Tribunal, whose retrospective jurisdiction had no express time limits as opposed to some other international tribunals, whose powers were confined to time periods. We are inclined to accept this suggestion because our charter permits us to adjudicate on crimes against peace, which many ad hoc tribunals do not have the power to adjudicate on. Now, on the issue of the immunity of sovereign states from criminal process in foreign courts. 1. Can foreign states be impleaded before the Kuala Lumpur War Crimes Tribunal? Our charter in Chapter 3, Article 6b is explicit that, I quote, if the charge involves a sovereign state, a current head of state or government, service of a copy thereof to any relevant embassy or high commission shall suffice, and the accused is deemed to have been served, unquote. 2. The jurisdiction that the international law doctrine against impleading a foreign state must be read subject to a more peremptory norm of international law, jus cogent, that prohibits the crime of genocide, as can be seen in the following 2 ICJ judgments, namely 1, the Democratic Republic of the Congo against Rwanda, 2006, and 2, the application of the Convention on the Prevention and Punishment of the Crime of Genocide, Bosnia and Herzegovina against Yugoslavia, February 2007. 3. We are in agreement with the prosecution citation in the ICJ case, which is the application of the Convention on the Prevention and Punishment of the Crime of Genocide, Bosnia, Herzegovina, and Serbia and Montenegro, 2007, which states that, and I quote, the court observes that duality of responsibilities continues to be a constant feature of international law, which is reflected in Article 25, Para 4 of the Rome Statute for the International Criminal Court. Thus, if an organ of the state or a person or group whose acts are legally attributable to the state commits any of the acts prescribed by Article 3 of the Convention, the international responsibility of that state is incurred. Thank you, President.